Welcome to the Exhibit A podcast.
Hello and welcome to Exhibit A, where we have meaningful discussions about family law, estate planning, and other legal topics that you're probably going to be interested in. Today, I wanted to discuss the importance of having a will during divorce proceedings. And with me is none other than Ali Smyser, our experienced and, may I say, excellent estate planning attorney who works for our firm. Hello, Ali.
Hi, Don. Good morning.
Good morning. To start off today's discussion, I'd like to tell a story, if you don't mind. Now, I bore you with a lot of stories, but this one I think you're going to like. I want to tell you about our first client that this firm ever had. She retained us, I think, probably on day one of when I opened the door. And Ali, when I'm finished with this, I'm going to ask that you weigh in on the legal issues that was involved in this case. So let me start off with the story by introducing you to my client, whose name was Jacqueline. Jacqueline was a 76-year-old woman. She was married, and she had been previously married, and her and her former husband had a child. Now, the child was 50 years old at the time that Jacqueline came to my office. The daughter's name was Brenda. Now, Jacqueline owned a house prior to her second marriage where she and her 86-year-old husband, whose name was Abe, resided. So they lived there for about 20 years. And remember, this is her second marriage and his second marriage. When I met Jacqueline, she described her marriage as being broken. Abe was abusive, and he was squandering all his money into a separate account, making her pay for all of the bills and making the mortgage payment on her separate property home. So Jacqueline wanted a divorce, but she was really there to see me because of something very near and dear to her heart. She revealed to me that she had cancer, and the doctors gave her less than a year to live. And Jacqueline desired to obtain a divorce because she wanted her daughter to have the house. It was a house that they owned before the marriage, and she didn't want her husband to walk off with the house. Well, fortunately, I had attended some seminars and spoken to some people, and I knew that after I was retained that I needed to get Jacqueline to a estate planning attorney like yourself. This was before you and I ever knew each other, many years before that. And the estate planning attorney went ahead and did the will for her, and then we filed for divorce, and the divorce proceedings began. And it was the usual stuff. We engaged in some discovery. Abe was served with the summons of petition. He got an attorney, and things were going pretty smoothly. But after about 9 months, I got a phone call that Jacqueline was in the hospital, and she was on her deathbed. And so what we did very quickly is we spoke to opposing counsel and persuaded her to allow us to get what we call a bifurcated status of their or marital status. We got their marital status dissolved by way of a judgment and left all of the property issues still in dispute. She agreed with that, and believe it or not, we sent my wife, Maria, to the hospital who met Jacqueline, and Jacqueline, who was very, very sick at the time, couldn't even lift up the pen. Maria had to lift Jacqueline's arm up to actually sign the judgment of dissolution. Abe signed it on the same day, and the very next day, Jacqueline died. It was very, very sad, very dramatic, but we had these people divorced one day before she died. And as a side note, unfortunately, Abe, who was probably heartbroken because he didn't want the divorce, he died 1 month later.
Oh, my gosh.
So what we had in this case is we had a divorce with property that needed to be divided, and neither party was still alive. So the real parties in interest were the parties' children. We had Brenda on Jacqueline's side, and Abe had a son that lived in Arizona, and he was the real party in interest on the other side. Now, that's all I'm going to tell you about the story right now. I could go on and on about some of the curves that we encountered, but I want to ask you some basic questions that I think that our listeners want to hear. First of all, do you think that it's important for most people to have estate planning, or at the very least, just a will?
Absolutely. Everybody over the age of 18 needs to have a will and some simple documents that will protect them, if they become disabled or when they die. People that are going through a divorce, absolutely, preferably before they file, but we can do things after they file as well, need to at least have a will. I mean, yours is quite a dramatic case, and you sort of knew going in that Jacqueline was ill, but we have plenty of people here at this firm, right, that seem healthy and okay, but divorce is very stressful and life is unsure, is chaotic, and they die. And so if you want your property to go the way you want it to go, not the way the state thinks it should go, yes, you need to have a will.
Okay, great. So in this case, with Jacqueline involved, how would it have been different with regard to her desires had she died without a will?
Well, then it goes by what's called intestacy, right, which is the state, the probate court, or the probate code determines how they think people would want property to be distributed. And what that looks like is 100% of community property goes to the surviving spouse.
It would have gone to Abe at this point.
It would have gone to Abe.
Okay.
For separate property, if there was one child, Brenda was
she was the only child.
She was the only child, thank you. 1/2 would go to Abe and 1/2 would go to Brenda.
Which would have been exactly what you wouldn't have wanted.
Exactly.
Okay,
yes.
So by having a will, at least we know that what would happen?
By having a will, then Jacqueline can decide. Now, of course, she can't give away what's not hers in terms of the community property, but her 50% of the community property, she can distribute however she wants, and her separate property she can distribute however she wants.
Okay, and in this case, we're talking about a house that had a component of separate property and community, because during the marriage, there were payments being made towards the mortgage. So it was mostly separate with some community, and would it be fair to say that she would have received, Brenda, I'm saying, all of the separate property of the house, and then 1/2 of the community?
Yes, as long as that's what Jacqueline had in her will.
Okay.
Yes.
All right. Now, let's talk about the other part of this story here, and that is people who die during the pendency of a divorce. Okay. First of all, what happens to that divorce claim?
Oh, well, it dissolves, right? It dissolves if they're still married. Because one of the parties dies, they're still married. The surviving spouse is a widow or a widower, and it goes from the family court to the probate court.
Okay, where things change dramatically, don't they?
Absolutely, change dramatically, and the family court is very well equipped to deal with separate and community property issues and the real specific and fine lines in those. And not that the probate court is not, but the family court just does a much better job, I think.
Okay. Now, when you're talking to people that have these type of issues, is there a pat answer for all cases?
Oh, never, right? like every individual person, every individual marriage, every individual death of someone, it's very specific to their personality. So it's very important that people get a good, thorough consultation with an experienced attorney.
Let me ask you some other questions that our listeners may be interested in knowing, since we've brought up this topic. One of them is can people create or alter wills without being in trouble by the family court during the pendency of a divorce?
With a will, yes, absolutely. A person that is a party to a dissolution action can execute a will, can change a will. Trusts are a different story.
I was going to ask you about that. So tell us that part of it.
So the ATROs, the automatic temporary restraining orders, prohibit the funding of a trust. One of the parties can establish the trust, but we can't fund it. So that limits our options, which is why for our clients, I like to be able to talk to them before they file, just to determine if it's appropriate to think about doing a trust. Sometimes it is, sometimes it isn't, but at least it leaves us more options.
Okay, it's a conversation that should be had at least, right?
Exactly.
Okay. Now, when it comes to estate planning in general, are you surprised by the number of people who do not have any form of estate planning?
Yes.
Okay.
I mean, I think more and more I'm seeing that people have it, but gosh, each day I hear about people with many assets, very high wealth individuals that have done nothing or that have a will from 1976, So everyone has to have estate planning, And if you haven't looked at your estate planning in a long time, and even 5 years, 10 years, pull it out, take a look at it, make sure it's what you want still.
So you would recommend that it be updated every once in a while then?
Correct.
And you're saying 5 to 10 years?
Yes, yes.
What could happen in 5 to 10 years that would make somebody want to update a will or their estate planning?
Who knows what has changed, right? So divorces, children being born, grandchildren being born, your children getting divorced. So maybe you've named, and this happens quite a bit, a client, a settlor of a trust will name a daughter-in-law or a son-in-law as a trustee or in some kind of role. But now that person has divorced their child, so you might not want that person named. The other thing that happens quite a bit is a beneficiary is named on a life insurance policy or an IRA account, or a CD even. People don't remember, in that moment that you're sitting in the bank, you say, oh, I want it to go to this person. And then they it's out of sight, out of mind, right? So it's also a good time to look at your accounts, see who's beneficiaries on them, make sure that that's still what you want. It might all still be fine. It might all still be what you want, but have the peace of mind to know that you have the right people on there.
Yeah. We're talking about, at the end of the day, sleeping better at night,
Exactly.
right?
Exactly.
So now with regard to estate planning, there's other things that Jacqueline should have been concerned about when she saw that probate attorney, or the estate planning attorney, I should say. Tell me what else you should have been concerned about.
Well, really important in my mind for our clients while they're going through the divorce is, even if there's not a property issue, I like them to have a power of attorney and an advanced healthcare directive, because while they're married, that spouse, even though they're an opposing party in a dissolution proceeding, they still stand first in line to make financial decisions for you and healthcare decisions for you if you're not able. So God forbid you're in an accident or you're ill or something happens and you're not able to make decisions on your own. That spouse,
oh my gosh,
even though you're estranged,
could be the last person in the world that you'd want to do that.
That's exactly right.
Okay.
That's exactly right.
Okay, great. Well, I want to thank you for educating us all, including myself, about these very important topics. And I think that's all we have for right now. I want to thank our listeners for joining us on Exhibit A, and we hope you join us next time, where we will provide you with more interesting discussions on topics of the law. And Elliot, I hope that we get you back real soon on some related topics that I think our listeners are going to just love. Thank you very much.
Thank you.
Exhibit A is produced by David Lindley at the law offices of Donald P. Schweitzer in Pasadena, California. For more information, visit us online at PasadenaLawOffice.com and all social media platforms.